the Supreme Court resolution ordering the immediate release from detention of Mrs. Gigi Reyes, once the aide and chief of staff of the former Senate President Juan Ponce Enrile, is an important ruling with serious implications. For lawyers, it raises the question, has a new form or a new dimension of the writ of habeas corpus been discovered or invented? And for ordinary citizens like us, it prompts us to ask, just how long is too long to be detained while undergoing trial? Good evening, I'm John Nery, and you are in the Public Square. Mrs. Gigi Reyes spent 3,116 days in detention before her release on provisional liberty on January 19. The resolution of the First Division of the Supreme Court was categorical in its language. First, in its ruling, and I quote, "Her confinement, though in accordance with the court order of the Sandigan Bayan, has become oppressive, thus infringing upon her right to liberty." And second, in the court's approach to the habeas corpus case itself. Again, I quote, "In light of the foregoing, this court finds it imperative to lay down the standards in the grant of the writ of habeas corpus anchored on a violation of the right to speedy trial." What do we make of that? What should we make of that? Tonight, we are joined by three resource persons who can shed light on this issue. Attorney Theodore Te of the Free Legal Assistance Group is a professor of law at the University of the Philippines College of Law. He is also a lecturer at the Ateneo de Manila and De La Salle University Law Schools. And from 2013 to 2018, served as the spokesperson of the Supreme Court. Attorney Kristina Conti is a public interest lawyer, a leading light of the National Union of People's Lawyers, or NUPL, and the Public Interest Law Center. And colleague Jairo Bolledo is the Rappler multimedia reporter covering the Justice Beat. His reporting helped readers make sense of the resolution and its potential implications. Welcome, Attorney Ted, Attorney Kristina, Honorary Attorney Jairo.
Good evening, John. Thank you.
Good evening, John.
For having us here.
Let me start with Jairo. When did Mrs. Reyes file her habeas corpus petition? And how long did it take for the Supreme Court to resolve the issue?
Yeah, actually, I listed down all the important dates regarding the ruling. So, the resolution was released, as we know, on January 17, 2023, but it was publicized on January 19, so just last week. Gigi Reyes filed her petition for the writ of habeas corpus on January 13, 2021. So that was 2 years ago. And then after 2 weeks after she filed the petition, the court immediately acted on it and it asked other respondents, including Taguig City Jail and the OSG, to file their comments. The last one which filed the comment was the OSG in March 30, 2021. And then after that, medyo nag-take ng ilang months. And then the most latest one was January 5, 2022, last year. Inutusan ng court na mag-file ng memoranda yung lahat ng parties na regarding sa petition ni Gigi Reyes. So it took around 2 years before the writ of habeas corpus was granted.
Although she was detained in 2014,
Yeah.
And her trial started much later than that, right? Attorney Ted, as an ordinary reader of the decision, I get the sense that the reasoning of the Supreme Court applied in this case can apply to other cases. That's the sense I get from the language. No? Is there a legal or... I understand you've written on this already. There is a legal and jurisprudential basis for thinking that it might apply to other cases?
Yes, I do. First, I think we need to point out that the court issued what is called an unsigned resolution. So if you see it, you don't see the signatures of the justices.
That's right.
It's only attested to by the clerk of court. And under the internal rules of the Supreme Court, an unsigned resolution is usually applicable only to the parties. And while it resolves the case on its merits, has no significant jurisprudential value. So that is on one side.
Okay.
But on the other side, as you pointed out in the opening, the court used categorical language. And here, the court also issued guidelines as to how we will treat habeas corpus petitions anchored on the violation of the right to speedy trial. And this is under the court's rulemaking power under the Constitution. So when the court does this, the court is basically telling the public, this is how we will act in the future, right? And so on that basis, because the court did issue guidelines, so my impression is that this case could apply even to others similarly situated to Mrs. Reyes. Of course, the way to do that is for others to file petitions for habeas corpus invoking this ruling and hoping that the Supreme Court, will grant their petitions anchored on this ruling. So then it becomes jurisprudence. Then it becomes doctrine.
So the real test or measure of applicability is to experiment and to actually file a case.
To actually file another case
with the Supreme Court.
With the Supreme Court, citing this.
Okay. Yes. Attorney Kristina, this might be one of those rare instances when you will agree with Justice Secretary Remulla on something. A few days ago, he said that this might, in fact, apply to Senator Leila de Lima. Do you agree? Why? How can the lawyers of Leila de Lima use this to their advantage?
Well, yes, I agree that it could apply to the case of Senator de Lima because according to Sir Te, who was my professor in criminal law review, the guidelines set down refers to circumstances in the case.
Okay.
So it's not like in the Enrile case. There's another case that involved, Senator Enrile, and it entitled him to bail because of his particular circumstances. So we had been citing that case in several other cases that we said we have elderly prisoners, we have prisoners who are at risk of disease. Actually, during the COVID petition, we cited in the COVID petition, we cited that ruling, and the Supreme Court said no, that will only apply to the exact circumstances of Enrile. But in this case, there was no, in setting down the guidelines, there was no reference to you have to be a Gigi Reyes, you have to be old, you have to, and so forth. It only referred to cases. So what we have to do for lawyers of not only Senator de Lima, but also of political prisoners who have been long detained. And one thing in the guidelines is that they said that Gigi Reyes invoked her right to speedy trial as early as this time. So, in political prisoners' cases, actually, we've been invoking as early as a pre-arraignment remedy, the point that they should not have been in jail in the first place. So this is, similar to that because the right to speedy trial says that I've been in jail for too long. In this case, the fact that your constitutional rights have been grievously violated is significant because in most political prisoners' cases, I'm just making an emphasis on that, are prosecuted because of, political pressure, trumped up charges. And actually, we're looking at one particular case right now, which has run as long as 9 years. This came from Cebu, na-transfer na siya, nagkaroon na ng mga hearings, we had a pre-arraignment remedy, the motion to suppress. Okay, not going into the details, but we had a motion to suppress evidence, and then we're now in trial, and we're only at this, as in particularly, second prosecution witness. So, ang tagal.
Oh, wow.
So, we're looking at another possible case aside from Senator De Lima's. In Senator De Lima's case, a lot has happened. And of course, there's a lot of cases. But I do believe that in the different cases that she has clearly invoked the right to speedy trial. And yung development, di ba, ang daming umaatras na witnesses na in the first place, there should not have been a case at all.
Attorney Ted, I want to go back to the point that you raised about the nature of the decision. It's a resolution, as you emphasized, unsigned.
Unsigned.
It's of the first division, so the nominal chair is the Chief Justice, who recused himself because he was Sandigan Bayan before. The working chair is Justice Hernando. And then you have three other justices, Marquez, Zalameda, Rosario. No? This is such an important case with potentially serious implications. Why do you think it was coursed through the form of a resolution? I mean,
it's hard to speculate why it came out in the form of an unsigned resolution at that. Again, just to differentiate, no, if it were a signed resolution, then it could have again disposed of the case on the merits, could have jurisprudential value. It would have been better if it were a decision, but because it did not contain the signatures of the justices, it's treated as an unsigned resolution under the internal rules. An unsigned resolution has no jurisprudential value. It only affects the rights of the current parties, and so has to be invoked. Now, as to why they did not sign it, I really can't say, because it could have been, they could just have very easily told the clerk of the division, convert this into a formal decision, and we will sign it. Right? It's really just formatting, because when they vote, they don't vote and say, this is only for an unsigned resolution. So it could basically be formatting. It could basically be someone saying, okay, this is what we decided on, but since there was no instruction to put it in the form of a decision. So it's hard to speculate. I myself was wondering about that when I read it, because when I saw that it was an unsigned resolution, I thought, okay, this applies only to Gigi Reyes. But then when I read the guidelines, I said, well,
why are there guidelines?
Why are there guidelines, right? Because they did not need to write the guidelines. They could just have very well easily disposed of the case, granting it to her, and then it would apply only to her. And then for all others, they would have to cite it and try their luck. But here, the court went one step further. It gave guidelines. So it was a signal to the bench and the bar that in all future cases, we're going to treat all future cases in this manner. So here is how you should proceed if you have a client similarly situated. So again, it's a very strange situation. Because in previous instances where the court came out with guidelines, it usually comes out with it in a decision, so that you see the justices sign it, because it becomes part of the rules. It becomes part of it's essentially soft law, as it were.
Soft law. Just one more thing. We can reasonably assume that the 5 members of this first division were unanimous behind this, because there were no dissents.
There were no dissents noted, because it's possible to note a dissent in an unsigned resolution even. There were no dissents noted. So yes, it's safe to assume that it was a unanimous 5-member division.
Is it possible to speak of the Supreme Court as possibly testing the waters for a new doctrine? What do you think?
Well, I am not familiar with the inner workings of the Supreme Court. Sir Te would be in a better position to say what the court could possibly be leading to. But a study of the decisions of the Supreme Court recently tells us that, in a way, the Supreme Court is trying to break out of some, let's say, shortcomings of the law. In fact, I'm looking at this case as a sort of a remedy to the rules on on recognizance from another perspective, because recognizance allows you to be released without bail, but in similar circumstances. So this is temporary release.
Okay.
Habeas corpus is actually a remedy that is used for, permanent release.
Okay.
As was invoked in, I think this was also discussed by Jairo in his article, The Case of Dennis Velasco.
That's right.
You're saying, no, there is no basis to detain this person, you should release him. But the rules on recognizance say that a person can be temporarily released, and because this person has no money. So this is a sidestepping bail. So this is actually directed towards, indigent clients, prisoners without money. So it is not conditioned on security, on financial or property bail. In this case, you're allowing a detained person to be temporarily released without security, but on the condition that she has to show up in court, which is the only requirement for a person to be released temporarily. For those who should have availed of the right to recognizance, it seems eerily familiar. Kasi ganun din eh. No security, temporary release, and you have to show up in court and sort of report, actually.
Yeah.
Actually, for recognizance, you also report. Or you come up with conditions with parang yung guarantor mo, so the person who stands for you na may custody sa'yo. And it's important to note that, well, Mrs. Gigi Reyes is not an indigent client, by any means. So parang nakikita ko, baka pwede pa to na remedyo because very few people can avail at this point. Ang hirap no, nung rules on recognizance. It's so hard to qualify. Kaya nakikita ko, kahit mahirap ka, ano tong mga requirements? Ang dami. Huwag na lang.
If I may, John, just to add, no,
Kaya-
recognizance is also something that the law provides. So, and it's only provided in very specific offenses, no, minor offenses. So, I agree with Chrissy that it broadens the space, no, not just for bail, no, but also for habeas corpus, no. So, and to your question of is the Supreme Court trying to do something here? I think it is. No, I think it is. Maybe not as directly as people would want. Maybe not as obviously as other people would also want them to do it. I think this decision and previous decisions on habeas corpus, for example, have been trying to chip away at some of the limitations on habeas corpus. And just to maybe emphasize that, no, habeas corpus is so important a remedy for someone who's detained. Because if you've been illegally arrested, it's your first recourse. And traditionally, and this dates back to the ancient times, it's a really, really old writ. And it's essentially, produce the body, right? Show to me the cause of restraint. And so that's a really important weapon for someone who has been unlawfully detained. But of course, through the years, the limitations put in by the court itself through its decisions have limited it to the point that lawyers hardly avail of habeas corpus anymore because they know once your client has been charged, you're not going to get habeas corpus. And that's why amparo came out. That's why habeas data came out, right? Because of the limitations on habeas corpus. And so this might represent a shift. And this is, I think, the court signaling that, we're opening it up a little bit, right? And
So if the court,
try your luck.
If the court is sending signals, I think it's incumbent on the legal community
To read it.
Yeah.
and civil society to read it and to
read it
respond
correctly. Yes, correct. Yeah.
Diyan I
go
have
ahead.
a question for Aide and Attorney Kristina Conti. Speaking of recognizance, Reyna Minasino, one of the latest activists
Correct.
freed in fact last year, she also filed for petition for recognizance, but I don't know if it was granted because she was freed on the basis of she paid surety bond, around 282,000 pesos. Na sino is indigent, she paid for it, she has no money, activist siya full-time, and yet she had to come up with the money. What's with the new rules on interim habeas corpus na wala sa recognizance that might be...
Well, again, I think Chrissy pointed it out. It's not connected to the person's condition. It's connected to the right. So that, I think, is a big shift, right? Because the right is guaranteed under the Constitution. So if you can point to the right and you fall under the guidelines that the Reyes resolution sets forth, then you might fall under it. Secondly, the court distinguished it in the Reyes resolution that this is not bail by any means, right? It's saying habeas corpus. And so it's essentially release while the case is pending, because the court also took pains to distinguish that. We are not making a prejudgment on her guilt or innocence.
That's right.
They're saying the trial must continue, regardless of whatever stage. We are simply releasing her because the right has been violated, has been shown to have been violated, and would continue to be violated if she were still in detention, right? And so, so in that sense, it's an additional, I think, tool, no? In the case of Reyna, yes, recognizance was not allowed again because the law on recognizance is quite limiting. So perhaps and because it's Congress, Congress might see fit to maybe expand the instances when recognizance is allowed. Before the law on recognizance came out, recognizance was something that judges had the discretion to grant because there was no law limiting it. So the judges, for example, in the provinces, in the regions, where you have more people who really could not afford the amounts of bail, the judges would simply say, kilala mo ba ito? Meron ka bang, sigurado bang kilala mo to? Pwede mo ba siyang i-produce pag kailangan ng korte? Because magkapit-bahay magkakakilala lahat So they bring someone of sufficient stature, maybe the barangay chairperson or whoever.
Or the parish
Or the
priest.
parish priest usually, right? Or someone from the LGU and say, ikaw na magagarantya diyan, no? So and so that was something that was a little bit more simple. But when the law came out, of course it limited the instances, right? And so the judges cannot operate beyond what the law says, right? And so maybe the solution there is to carve out greater space in the law. But here, what the court is doing is creating space, I think, and through this interim writ, no, pendente lite, meaning while the trial is going on. And I expect there will be a lot of cases. Public interest lawyers, human rights lawyers, would have so many clients who would probably fall within the guidelines set by the court. And so I expect the courts to be, deluged by petitions for habeas corpus. I don't know if the court had foreseen that when it came out with its guidelines.
I have to say...
If I just
go ahead.
Point out rather a very, very substantial aspect of the case of Ina Ram Alma. In that case, so a search warrant was served. When it was served, they said that they found firearms. So they're being held on illegal possession of firearms and explosives charges. The court said that the search warrant was valid and, proceeded with trial. On that issue, valid ba itong search warrant? They went to the appellate courts. And the appellate court voided the search warrant. But here's the problem. The trial court, so wala na sanang search warrant. And any search thereafter, invalid na, fruit of the poisonous tree. The problem was the decision of the Court of Appeals had not had not lapsed into finality. So hindi siya final. You have to wait for it. So I think, I have to check with the NUPL handling team talaga, pero I think the state appealed. So hindi maging final. So inakyat pa talaga. Kaya, parang may cognitive dissonance kasi nagtatrial ka sa isang kaso na dapat hindi na naman nagtutuloy. In that case, sabi na nung Team Teka, what is the easiest or fastest way to get them out of jail? We had to avail of bail. Kasi hindi mo ma-cite yung substantial reason. So we had to find a procedural means to get them out of jail kasi pag yung substantial reason na wala namang search warrant yun in the first place or it was invalid, magugulo pa yung court, sasabihin niya, ganito kasi. So, in this case, yung Gigi Reyes case, I think could be, analogously invoked na there is already a violation of a constitutional right. Which is why, hindi naman pasok na tayo ng evidence, pero which is why medyo mahina na yung kaso. So, it would be better to release them to remedy the violation na nakulong sila at na-detain na. Kaya the carving out of space is really important because there are many matters that have both a procedural and a substantial component.
A couple of things before I turn to Jairo. So recognizance usually applies to minor cases, but this is not exactly a minor case. This is a capital crime of plunder, right? And then the second thing, the Supreme Court, in sending the signal, is in a way in sync with the Justice Department's current thrust of releasing so many prisoners deprived of liberty. I don't know if that's something that we can study further on. Anyway, I wanted to note that before I turn to Jairo. Jairo, you've read the resolution. It has a bit of arithmetic in it. Right? How can you walk us through the Supreme Court's decision-making process in calculating just how long Mrs. Reyes spent in detention?
Yeah, to put into perspective, when the PDAF scam exploded, the issue of the PDAP scam exploded, I was in high school.
Okay.
Wow. Wow.
I think he can be sued for offensive.
And when she was charged before the court, I was already in college, and now I'm a working reporter covering.
Wow, but thank you. That really sets it in
So,
perspective.
Yeah.
Yeah, it's been 9 years.
9 years.
To put into timeline,
Yeah.
Gigi Reyes was charged with plunder in June 2014, and her commitment order was served the following month, July 2014. So basically, she has been under detention for 9 years, and it's also important to note that she noted in her appeal that she invoked different motions for release. So sinabi niya na ilang beses na siyang nag-try ng bail,
Yeah.
and then yung last resort niya daw, something like that, is the the writ of habeas corpus. In her one of her petitions, in one of her replies to the court, sinabi niya na yung original habeas corpus law was already repealed, so that gusto niyang invoke na lang ancient ruling on habeas corpus, the most
The
effective
17th
one.
century.
Yeah,
The great writ.
the great writ
The
of
great
habeas corpus. So, also one of the interesting points that she raised in her petition, the number of days ng mga fellow accused
Yes,
niya.
yeah.
So, to put into perspective, former President GMA, she spent 1,387 days. Revilla spent 1,643 days. Estrada was spent 1,188 days, and then Enrile, yung connected sa kanya sa case, only spent 413 days. So the court also took note of that because Reyes spent 3,116 days from the service of the commitment order from July 9, 2014 to her release in January 19, 2023. So that's how long.
Yeah, about twice the length of Bong Revilla's stay in detention. Attorney Ted and Attorney Kristina, how long is too long? The court says it's not a matter of quote-unquote mere mathematical reckoning. So there's the Barker balancing thing, there's the Kagapang criteria. But for us laymen, how do you answer that? How long is too long?
If you're talking about detention from the point of view of an innocent person, 1 day is too long, right? But for practical purposes, if you're looking at the resolution of a case, and I think that's where the Kagang and the Barker balancing test came in, because that's always been an elusive concept for the courts. Because there are timelines that are set, but of course, usually those timelines are exceeded. Diba? They have to consider many things. For example, part of them, number of people involved, complexity of issues, number of issues and complexity of issues raised, number of witnesses expected. And here we're probably talking about primary witnesses, not just corroborative, because in corroborative you can waive them, you can dispense with them. Who has the burden of proof? Even resources. No? So all of these go into determining how long a case has progressed and whether there is what we call undue delay or inordinate delay in the case. No? So I'll just give an example. For example, if you were talking about a case involving 100 accused, hypothetically, right? 100 accused, each of whom is entitled to lawyers, a separate lawyer, if they each prefer a separate lawyer. That's 100 lawyers already, right? Each of whom is entitled to their day in court, individually, even if you try them together, right? And you're talking about, let's say, a murder or several murders, okay? And you have one person, right, charged with, let's say, murder, and then represented by a lawyer, right? So you're talking about the same offense, but number of accused would be different, right? So you would say 10 years for that single accused charged with murder is too long, right? Kasi mag-isa yan eh, di ba? Kaya mo naman tapusin eh. But for example, if you were to say 10 years for the 100 accused, no? Baka sabi mo relative, baka hindi, right? But I think that's what the Barker test and the Kagang test is trying to say. When the court is saying it's not simply mathematical or arithmetical. But again, that doesn't answer the question from the point of view of the detained. Diba? Kasi kung dinetain ka na sa tingin mo, walang basis yung detention mo, no? 1 day is too long, no? 1 minute is too long, di ba? And so I think the court will have to come up with something, no, a balance wherein the accused would be able to satisfy his or her right to a speedy trial or even a speedy disposition of cases, which is different, no? And where the court can also discharge its role, no, to dispense justice, no, dispose of cases in a speedy manner, considering all the circumstances. What that is, I don't think it can be resolved simply by computing, no? Marami kasing factors that go into delay, no? Litigiousness, number of crimes. And I've said this before, no? Almost every law that Congress passes has a penal sanction. Meaning, when you say a penal sanction, there's a crime involved. And so, there's a crime involved, people will file cases based on crimes. Diba? And so, dumadami yung docket ng court. Diba? At bail is too high even for those who are entitled to bail. No? And so, they stay in jail. Tumatagal din yung cases. Diba? So, kombinasyon yan . So, it cannot just be the court itself. And I'm speaking as someone who has tried cases and someone who's also seen the court working inside. No? Kailangan talaga may balance ng konti.
But Attorney Kristina, the court also said, indeed, 9 years is far too long of a detention pending the resolution of a criminal case. So parang may intuitive benchmark sila na at a certain point, 9 years is too much. How do we make sense of this?
Actually, the rules, in the variety of rules na meron tayo, there are numbers.
Yeah.
You have to be charged within 12, 18, 36 hours. You have to be arraigned within 30 days. You have, actually, for trial specifically, you have to have trial over or done within 180 days.
Okay.
That's what our rules say. So, dapat lahat ng nakakulong in 6 months, tapos na lahat yan. Tama ba? 6 months? Ano, mali tayong math. So, 6 months, tapos na lahat yung trial. Kaya lang, yun nga, there are many reasons how what happens. Pero I'd like to point out, in trial, ito yung nagiging practice. So, when you say unreasonable, taking this from a client's perspective, so sa mga detained, bakit hindi natuloy? Ang nangyayari, ngayon, si judge may sakit. The following hearing, si fiscal naman ang absent. The following hearing, COVID, things like that. No?
Yes, yeah.
So, you can't really say na unreasonable because the reasons vary. Pero we've seen this used or parang exploited na tipong every other week or every other hearing, absent si fiscal. Pero hindi naman siya yung continuous delay. Which is why the new rules on continuous trial, from what I've seen, mukhang nakakatulong siya to stopgap itong problema. Kasi previously, the hearings were set on the spot. Kumbaga, the next hearing will be, and there's just one setting, or maybe two. But now, dapat sa start ng trial, sa pre-trial, naka-lay down na lahat yung buong schedule of the court. Of course, it's not followed. In one of our cases, sobrang nakakadismaya, we had the pre-trial December 10, 2021.
Okay.
And then the judge says, okay, because of so many limitations, we have no court, we have no, etc. Your hearing will be on February 3, 2022. Oh, no, 2020. Yeah, 2020 pala. So we were like, I'm sorry, Your Honor, maybe you mean 2022. No, it's, sorry, 2021. So that was 2020. No, I mean 2022.
2 years.
Which was last year. Which is like, wala
1
po
year
akong
and 2
hearing
months.
ng isang taon. Yes. So, ang hirap kasi the court had reason. And it's valid. It's a new court. It was just set up. Nag-hearing siya sa elementary school.
Oh, wow.
Tapos walang provisions for internet. So, ang hirap din. And it was a drugs court. So, it had to deal with all these 1,000 docket.
Yeah.
Kaya ang hirap din nga talaga ng if you put numbers. But as the court says, 9 years, maybe at one point really, mapapaisip ka na, bakit sobrang tagal? Considering that, we go back to what is in the law. 6 months dapat tapos na yung trial.
Jairo, In your explainer, you mentioned the case of Dennis, no?
Yeah.
Yung one of the Human Rights Day 7 filed the petition and then was rejected. The case was dismissed essentially because by citing the Ilagan versus Enrile case. I'm sure you must have been struck reading this resolution. Not a single mention of this case. What do you think that implies for this resolution and its implications going forward?
We talked to Attorney Ray Cortez, the president of NUPL, who handled some of the cases, and he talked about the case of Dennis Velasco. So apparently, as one of the remedies to get Dennis Velasco out of jail, they filed petition for writ of habeas corpus on the ground that he should not be in the jail in the first place. Apparently, it was rejected because he was already charged. And the court cited the Ilagan v. Enrile ruling, which states that you cannot invoke you cannot have the privilege of writ of habeas corpus if you're already charged before the court. So what happened was they tried to apparently Velasco was released from jail and they used the same argument on the
His case was dismissed.
his case was dismissed, citing the same arguments that they cited in the petition for the writ of habeas corpus. And not only Dennis Velasco, also Alexandria Pacalda, the Court of Appeals also denied the NUPL's petition for the writ of habeas corpus because apparently Pacalda they also cited the Ilagan v. Enrile ruling. So, yun laging sinasite ng mga defense lawyer, mga public interest lawyers natin na nakaka-hurdle dun sa kanilang process ng pag-invoke sa writ of habeas corpus, which led me to asking Attorney Te and Attorney Conti, ano nang magiging implication po ngayon ng nitong ruling na to or nitong resolution na to ng Supreme Court dito sa Ilagan v. ruling? Kasi apparently, the writ of habeas corpus can only apply before the charge and then post-conviction. So, what will happen now?
That is the practical effect of Ilagan. It moots a petition for habeas corpus because there's now a process, an order that justifies the detention. So, moot na. Yun yung main point ng Ilagan. Unfortunately, Ilagan was carried over. Martial law pa yung Ilagan eh. And Ilagan involved, Ilagan involved a PCO. So, post-Marcos, dapat wala na yung PCO, di ba? So, ang punto lang naman is that kung illegal from the start yung arrest, dapat yung habeas corpus pwedeng bumalik. Tingnan kung bakit inarresto in the first place. So, but the mooting effect of Ilagan was, moot na siya eh. Kasi meron ng order eh. Ang problema nga, PCO yung in-issue against si Larry Ilagan, no? And in a post-Marcos 1987 Constitution era, sinight pa rin ng Ilagan. So, naging doctrine talaga siya. No? Paulit-ulit na. Wala na yung distinction because of the PCO. So, ngayon, any process, any order, moots habeas corpus. So, you now effectively have a remedy that's available only pre-charge. And the quickest way to guarantee that your client will be charged is file a petition for habeas corpus. Alam na ng pulis yan. Pag nag-file ka ng petition, i-charge nila yan. Mooted yung habeas corpus mo. And then you have, on the other end, a post-conviction remedy. And this was largely because of a 1971 ruling, Gumabon versus Director of Prisons, involving rebellion, where the Supreme Court said, pag may violation ng constitutional right, it voids the entire proceeding. And therefore,
even though you've been convicted.
Even if you've been convicted already. And therefore, habeas corpus now becomes available. So, yung gitna yung nawala eh. No, yung while may rule, while may trial.
On the one hand, you have the pre-charge.
Pre-charge.
And then
you
the other
have
hand, post-conviction.
Post-conviction.
This case brings us to the middle.
In the middle. Now, in the middle was Ilagan. Now, what's the effect? The ruling, again, unsigned resolution. It has no jurisprudential value. It does not invalidate Ilagan. And under the Constitution, only the court and bank can overrule Ilagan. Kasi under the Constitution, a division cannot overrule a precedent or a doctrine. So only the court and bank. So what this does is chip away at Ilagan. No? Yun lang yung term na magagamit ko eh. It creates space, it chips away at Ilagan until the point na irrelevant na Ilagan. Kasi pwede mo na i-cite to eh. Di ba? Until such time the court finally says, bali wala ni Ilagan. Hindi na natin ko consider na yan, tatapon na natin yan, no? And which would make everyone so happy. I mean, Larry Ilagan was a flag lawyer. The three of them were arrested while they were doing their jobs as flag lawyers, di ba? But we would be so happy if the court finally does that. But until the court and bank does it, it's still there. Except that, mas maluwag na ng konti, no? May mga rulings na kasi before na nag-chip away na eh. For one, there's this case sa Libo, no? Wherein the Supreme Court said, pag mistaken identity, habeas corpus pwede. No? Kahit na in trial, no? So may mga ganong exceptions na. So by creating exceptions, it actually undermines the Ilagan, no? So possibly for me, no, Ilagan's one of the worst rulings of the court, one of the worst doctrines, no. Hindi naman siya Dred Scott vintage, pero it's that bad, no. Kasi nga yung gitna, wala kang magagawa eh, 'di ba? But because of the rulings that chip away at it, I think it undermines it to the point that it becomes irrelevant. At such time, when the court is ready to say, ay, wala na Ilagan, wag na natin pansinin yan, then they can finally do away with it. But in the meantime, I think, as many lawyers have been doing over the years, is just to keep filing and then to keep saying, Ilagan should not work. And then the court will probably find an opportunity to say, yes, I agree with you. Baliwala ni Ilagan. Di ba?
Actually, Velasco was really designed to counter Ilagan. That was our test case, kumbaga, for Ilagan. Although, it really began as a parang pre-charge remedy because we filed it, actually, both the Alex Pacalda case and many other cases, we filed habeas corpus before the charge was filed in court. So, dun pa sana siya. But then, our allegation or our point was, their arrest was illegal.
Yeah.
Which is why, tapos nag-file ng case, nagtuloy ng trial, kumbaga, pumasok na sila dun sa, kumbaga, during trial. But then, laging pansangga yung Ilagan. So, Velasco was really designed to, alam namin na mapafile na ng charge magkakasabayan in the case that I handled also for Lady Ann Salem. We did not file because we said, Velasco and another one will go to court with the habeas corpus, will do this. So really, it's a variety of options that you can do. Anyway, in other cases as well, pwede talagang habeas corpus yung gagamitin mo na, as we said, it's the great writ, na parang catch-all. Kumbaga, we had another case na mistaken identity. So this is the case of Rolly Panessa, that's the security guard who was detained on the allegation that he was top-ranking NPA commander. Security guard sa umaga, sa weekday, pag weekend, umuwi daw sa bundok. And they said that siya yan, because of what? A mole at the back of his, at his nape, ganyan. And then, because he had a wife, and at the time he was arrested, he had a wife. We had his wife with him. So sabi, ito naman si whoever. Parang sabi namin, hindi talaga. But then when you're in court, and you tell that to the judge na, Your Honor, this is not the same person who's charged in the case. But you have the military or the prosecution saying, no, this is the same person. And we'll show you during trial. Parang may ipit ka. Why do I have to go to trial? But I'm really not this person. So we went to the Court of Appeals. And this is precisely where actually we also hark back to a case, US case pa to kasi actually the writ of habeas corpus is a British concept na kinary on ng Amerika bilang kolonya, na kinary on ng Pilipinas bilang kolonya. Faye versus Noya. Sabi namin talagang if hindi ikaw yung tao that should be charged, it goes into the legality of detention. So the detention is illegal. So in this concept, it's two ways. Am I the right, which is the basis of the preliminary investigation, di ba? Sa PI, preliminary investigation, the main questions would be, is this accused the person who did the crime? And then second, is there a crime? In Dennis's case, we said, well, this is a person, kumbaga, nag-inquest This is the person, but he committed no crime. As in several other cases. In the other cases, no, this is not. In the Rolly Panesa, hindi ito yung case. Therefore, PI pa lang or inquest, we should not have gone to trial.
You know, we're running long. Let me just ask one last question of each of you, if you don't mind. Attorney Kristina, Jairo told us earlier, essentially this writ of habeas corpus case filed by Gigi Reyes took 2 years for the Supreme Court to resolve. Was that, I mean, I guess we can consider it fast, but could it have been resolved faster? I mean, the last filings were in January a year ago.
Yeah.
And then the Supreme Court took I mean, I don't want to knock the Supreme Court. This is a good decision. But could it have improved?
Well, I think yes, it could have been improved, especially that because it involves detainee. So sabi naman ng courts ngayon, laging may emphasis kami kapag nakakulong. But then, I would also like to go back to the beginning of this year when the Supreme Court announced that they were going to concentrate on public interest cases, human rights cases, and actually we've seen a lot of developments in the cases that we've handled, the JMSU, and ito, very material siguro sa mas marami, MRT, LRT fare hike. This is a 2014 case, nung nagtaas ng presyo. Wow. Yung MRT, remember? Oh, you don't remember?
Wait, you were still in high school then?
Yeah. They asked us to move in the premises. So, to update.
Okay.
So, we're looking at the next few months na magkakaroon ng developments in cases. And for me, I would like to qualify this as kumbaga, a public interest or a human rights case na pinrioritize nilang desisyonan.
Attorney Ted, I'm struck by the language used, as I've said, by this court. The use of perfect tenses, for instance. This matter, while legal, has become oppressive or had become a form of vexatious restraint. So the idea is that you have something that was legal that became unconstitutional during the process. Is this an unusual argument to make, even for a Supreme Court?
It's unusual in the sense that usually the court does not do that. No, it usually is a review court. It looks at things that have already been done. So you're correct in noting that yung present tense, no, is unusual. But still, because of the focus on the right, no, and I think the court was emphasizing the continuing violation, no. So that's why it uses that. It used present tenses. So, but tama yun, unusual yun, no. But just to say a little bit about the period, no. Habeas corpus is intended to be a speedy remedy. Dapat priority siya eh. It overrides all cases. So actually 2 years is long. I remember a case involving Rudy Salas. We went to the Supreme Court on habeas corpus. We filed it. In 10 days, we had an oral argument before the Supreme Court. The court eventually denied the habeas corpus, but the court granted bail to Rudy Salas. But we got an oral argument in 10 days. Within filing. No? So actually, I was struck by that. Mahaba yung 2 years. Kasi habeas corpus ito. Mahaba siya.
I see. To end, I'd like to ask Jairo, can you give us an idea? So what is Mrs. Gigi Reyes looking at now in terms of the timetable of her trial? And again, I'm struck by the language of the ruling. One of the conditions actually allows her to travel.
Yeah.
Subject to permission.
Subject to permission, but you know, she's not considered a flight
I think
risk.
maybe because she applied for permission before.
Yeah. So I just wanted to know, can she travel before her next hearing? What's next for Mrs. Reyes?
Yeah. I think we have to get the specific date pa kasi ng next hearing ni Gigi Reyes because yung schedule na nakapost sa Sandigan was until January 27 lang. So we have to check the next hearing schedule. But yeah, she can travel according to the guidelines provided in the resolution. I think another interesting part na pwede nating abangan sa case ni Gigi Reyes was ano yung mga next move ng kanyang legal counsel, especially that her lawyer is Estelito Mendoza, who scored 2 wins in the Supreme Court. Enrile, got Enrile out of humanitarian bail, and Marcos, he's the lawyer of Marcos na nanalo siya dun sa presidential candidacy sa case niya sa Supreme Court. So yun yung kailangan natin abangan kasi ongoing pa rin yung trial, especially on the other hand then, itong case din ni Gigi Reyes would shed light then and would reintroduce the ongoing trial din ng iba pang mga accused dito sa plunder case kasi parang nakalimutan na ng mga tao na in fact our chief presidential legal counsel Juan Ponce Enrile is still facing trials for alleged plunder. So yeah, yun yung maging perspective.
Together with a sitting senator,
Yes,
re-elected.
correct.
Re-elected.
Newly re-elected. Wow, there's so much to think about here. But Attorney Te, Attorney Kristina Conti, and my colleague Jairo Bolledo, thank you very much for taking time, for shedding light on this issue, and also raising the sense of possibility going forward.
Yeah, sabi nga namin, ang daming hashtag, sana all.
Sana
Sabi, dapat all.
Dapat all. Tama yun.
Okay,
Good job.
that could be a new category for filing before the Supreme Court. So again, thank you.
Thank you, John.
Thank you. Good evening.
That's it for us tonight. The next step for engaged citizens is always to take a more active role in rebuilding our democracy. See you in the public square. This is John Nery. Thank you and good night.